We're going to turn now to talk a bit about the climate with Anthony Roisman. So Tony is chairman of the Vermont Public Utility Commission. He's held that position since 2017, and at the time of his appointment, he was consulting with attorneys on environmental litigation, public participation before the Nuclear Regulatory Commission and state regulatory agencies. He has worked as a senior staff attorney at NRDC, chief of the hazardous waste section and special litigator for hazardous waste in lands and natural resources divisions of the U.S. Department of Justice, and as executive director of what is now known as Public Justice. So please welcome Tony Roisman.
Thank you. Like everyone else, I'm going to start by acknowledging Ralph. He was one of my first clients. I represented him in a suit to ban smoking on airlines. We lost the battle, but we've won the war, so not bad, I think. Ralph has a unique status in this country. Maybe even in the world. He is a bachelor with a remarkable number of progeny. Here we have the American Tort Law Museum, Ralph, Public Interest Research Group, Ralph, Public Citizens, Ralph, Center for Study of Responsive Law, Ralph, Trial Lawyers for Public Justice, now Public Justice, Ralph, and the list could go on and on. His inspiration has taken the idea of tort law, which was always considered a sort of secondary thing. Every one of us who went to law school had to take torts, so required course. Virtually no one ever thought they'd make a career out of it. And he's shown the public and us lawyers that that's really one of the first public interest law practices. And so Trial Lawyers for Public Justice, and now Public Justice, was founded on the principle that trial lawyers should have their skills used on behalf of the public interest, the same way as the more typical public interest law firms use appellate practice, or what we call motions practice, writing briefs, making legal arguments, but not getting in a courtroom, presenting facts to a jury or a judge, and changing people's minds and producing a result that will change conduct. So those steps are what I want to talk about today. And I want to start with a concept, and that is that tort law is the Swiss Army knife of justice. There are dozens of torts, and in the hands of creative tort lawyers, those torts are turned into legal cases that produce justice. I'll give you an example of just a few. We've got, if you go to Wikipedia, they have an outline of tort law. They've got over 30 torts. Intentional torts, property torts, dignitary torts, economic torts, nuisance, negligence, duty to visitors, strict liability torts, and under every one of those, a half a dozen other kinds of torts that you can bring. So what the tort law does is it takes those principles, which are common law principles, at least until they're interfered with by so-called tort reform. They take those common law principles and they ask a jury to answer one very simple question: where does justice lie? Nothing could be more fundamental to what makes this country special than that we allow a jury to decide justice between two or multiple parties. Think about it. If you as a parent lose a child as a result of some conduct or misconduct by a large corporation or even a private individual, you don't go to your local gun store. You go to your local lawyer. If you live in other parts of the world, you do just the opposite. You grab your AK-47, you grab your IED, and you rush out and you try to kill somebody. It is a remarkable thing that there is a system in which people who have suffered the most horrific harm would think to go to a court of law and ask to have justice done. And all these laws that you hear about, so-called tort reform laws, are so counterproductive even to the interests of the people who are urging the adoption of those laws, that it makes me wonder whether or not they are already suffering from some of the consequences of their misconduct. Maybe they've already got brain damage. Because if they kill off this spirit in this country that takes us to a court and not to a gun dealer, they are the first ones who are going to be at the other end of the gun. That kind of a revolution is not in the interest of any corporation, not in the interest of any billionaire or millionaire, not in the interest of any business interest, not in the interest of any conservative. That's not in the interest of anybody. But yet, they are still pushing those kinds of laws to deprive people of access to justice. We've heard today from a number of people about how those efforts have been succeeding, how the Supreme Court has been corrupted by money and politics, how various causes of action are failing to succeed in the courts. And that's much worse than it was when I started practicing law decades ago. It is time that we start to push back in a concerted effort, not sort of an isolated complaint, not write a letter to the editor because you're outraged by some particular piece of conduct. Every tort that's being committed in this country is part of a system that can be prevented if we as citizens use the power that we have to keep the good laws and get rid of the bad laws. If you want to start with a law to get rid of first, Citizens United. When your politicians run for office and they have their public meetings, ask them to make one pledge and do it publicly so that the press hears it. Pledge that they will vote to take money out of politics. Because as long as money's in politics, the richest guy wins. It's like Monopoly. You know, at the end of the game, who's the winner? One that has the most money. That's not the way we want our political system to work. We want the one who has the most justice to win. And we don't have a system right now that is doing that. So job one, get money out of politics. After that, it's just a matter of working out the legislation and the litigation that will do the best for most people. So I wanted to talk today about climate change. Sort of ironic, it's an exquisite day out. This is a day on which you would think, I don't want this to change. And it's interesting why it's so exquisite, because it's becoming increasingly rare. Remember the old saying, what is so rare as a day in June? Well, it is only a day in June. It used to be the whole month. Now it's storms, now it's flooding, now it's horrible heat or horrible cold. I live in Vermont. Our state is changing dramatically. If you just look at the flora and fauna, we look more like North Carolina every day. and I mean no disrespect for North Carolina, but I like the real winter that we have. That's sort of going away. Last winter, very cold, mostly ice. If you like to ski, that's not your favorite surface to ski on. So climate change has become a ubiquitous problem, and it's hitting in ways that the tort system can deal with it. It's hitting in ways that will make it possible to bring tort actions, and those have started to happen. We can just go down some of the torts, all right? Negligence. You design something that releases more carbon into the environment than it needs to release. You were negligent by doing that. Battery. Battery is a tort that involves physical contact with someone against their will. If you live on the coast and the water rises up and wipes out your house, and along with it damages you personally, you have been a victim of battery. If you worry that that's going to happen, you've been a victim of assault. Assault is a threat of immediate bodily harm. So you're sitting in your house, you take a look at the Weather Channel, and it says, look at this huge storm that's coming, it's a Category 4 hurricane, and you know that that Category 4 hurricane may cause personal injury to you, as well as conceivably wiping away your house. You're the victim of an assault. Public nuisance, you've heard about that already today. There's also private nuisance. Public nuisance is when the whole community has a nuisance, but individuals can also be the victims of nuisance. Trespass, that's obvious. The water is now in my basement. Now it's on the second floor of my house. Now my car is floating down the street. You've been trespassed on. No different than if your neighbor had a great big water tank and the water tank broke and flooded your house. That's a trespass, a very common early tort recognized everywhere. Intentional misrepresentation. Look at the ads that are now coming from companies like ExxonMobil or BP or the auto companies or anybody else who is a major source of carbon in our environment. They always tell you, we are working to protect the environment, we are reducing carbon. That's a false representation. That's not what they're doing. In a lawsuit, you could find dozens, thousands of documents that will show that they have a PR campaign over here and they have a product development group over here, and they don't match up at all. Product development is about new products that will sell more of whatever it is we've got to sell. That's what they do over here. So you've got intentional misrepresentation, tortious interference with business. Remember when BP had its little event in the Gulf? One of the largest group of lawsuits that were brought were by the businesses that were located along the coast that were damaged because they could not stay in business or because their businesses were reduced substantially. Vacation places, nobody wanted to go to the Gulf. Shrimp production, you were out trying to get shrimp. Shrimp were all covered with oil. You couldn't do shrimp. That's an intentional tortious interference with your business. Now, every one of those torts is a potential way to go after the people who are causing the carbon emissions. Now, you might say, well, but that's a long way from drilling a well and producing oil, turning it into gasoline and selling it, to the point of what it does to you. Fortunately, the science has established that linkage. And in tort law, there's this principle of so-called proximate cause. And what a proximate cause is it means that it was a foreseeable cause. Nobody who's producing carbon today, or probably over the last 20 or 30 years at a minimum, if not a lot longer than that, didn't know that carbon in the atmosphere would cause climate change. The consequences were proximate causes of those events. Now, will those suits be successful? No, probably not. Neither were the first suits that Fred Barron brought to fight asbestos. Neither was the first suits that J.D. Lee brought to fight cigarettes. We have to think about these issues by what in the movie The Sting is called the long con. You have to think about the long road. You're going to lose the first suit, and the second, and the third. Richard told you about suits that he's been losing, and he continued to lose them. But over time, every one of those suits is able to build on the prior suit, particularly if you're essentially going after the same group of defendants. The information that was available by the last cigarette suit that finally won, compared to the information that was available at the first, was much less. Much more later, much less. Every suit was able to build on the work that the other has done. And the goal is not to win the skirmishes, it's to win the war. And so, while there is an admittedly somber message that I know is being heard here today, that the tort system is under attack, that we as citizens are under attack, that corporations are grossly manipulating the system to their own benefit and to our detriment, I guess I'm essentially an optimist. I think that there is a path, but it requires one willingly suffering defeat and not giving up. And I think if we can do that, we can start to have an impact. The only problem with that, with the climate change, is we're running out of time. We don't have a lot of time. So we must not have an isolated suit here or an isolated suit there. And I'm happy to report that there is a growing number of climate change lawsuits. And a few of them have succeeded. They've gotten past the motion to dismiss. That's the early part of the case where the court basically says to the plaintiff, I'm not going to let you even get information from the defendant because the claim that you made is not sufficiently viable that it can survive. That's sort of what the issue is about what pleadings look like. The more the courts require you to know in the pleading information that you could only know after you've conducted discovery, the more difficult it is to keep the case going. But once you get past the motion to dismiss, once you're into the discovery stage, that's when the information starts to flow. Now, there's one very important caveat. Tons of cases that begin to proceed along the line of finding the smoking guns or their functional equivalent will settle. And in those settlements, the defendants dangle two things in front of you. Secrecy of the settlement. You can't tell anybody how much you got. And you have to return all the information they gave you, and you can't use it. Now, I'm going to tell you a story that I heard that happened decades ago in the early days when I was practicing law. It didn't involve me. There was a lawsuit that was brought on behalf of a discount drugstore in Washington, D.C. called Roisman's Discount Drug. And Roisman's Discount Drug was selling certain kinds of cosmetics and perfumes at very low prices, well below the prices that were being charged at the big department stores in Washington, D.C. that were selling exactly the same product. Well, the manufacturer of those products had said to the Roisman's people, we're not going to sell you the product anymore unless you agree to sell it only at the manufacturer's suggested retail price. And Roisman says, you don't have the right to make us do that. You can't do that to us. And they sued. And the suit went on for quite a while, and eventually the manufacturer said, okay, we will settle, but it has to be under seal. And this conversation in which the lawyers for the manufacturers and the lawyers for Roisman's were sitting at a restaurant in Washington, D.C., and the lawyer for the manufacturers said, do we have a deal? And the lawyer for Roisman said, no, we don't have a deal. And he then called for someone, this was back in pre-cell phone days, to bring a phone over. They brought a phone over to the table. He picked up the phone. He called the consumer reporter for the Washington Post. And he said, I'm sitting here at the table with, and he named the lawyer. He represents, and he named the company. And he said, he's just offered to settle our lawsuit over these pricing issues, but only if we agree not to tell anybody that he's agreed to settle for this amount of money, and only if we agree not to release the information that we've gathered as a part of this litigation. And the lawyer from the manufacturer was just outraged. He said, we're done, and he walked away, didn't even pay the bill. 3 weeks later, they settled, and it was all public. It's a bluff. If they're willing to stop that lawsuit, they're willing to let you talk about it. Don't let them hoodwink you. It's just a matter of standing up to the bully. He thinks that if he gives you enough money, he'll shut you up. If you do that, you've gotten this much justice when you could have gotten that much justice. So those of you who are thinking about doing something about climate change, stick to it. It's not going to go away instantly, but the losses will ultimately be the stepping stones to the victories. Thank you.